residential real estate, all ancillary issues regarding residential real estate, including homeowners associations. I also do all of our firm's transactional work, which is estate planning, probate, furniture. So that's a little bit about me. If you didn't get my card, if you want to get information about how to contact us, let me know. I have cards up here, so you can have them too. So we have an HOA, a homeowners association, and we have a community, I believe, with 89 properties, and we have some upheaval because we have a set of documents that doesn't really give us a lot to go from other than what we can't do, and we have some documents that are not part of our association documents, particularly bylaws, which bylaws basically tell us how we're going to conduct ourselves. When we have a meeting, who has the authority or what to make changes to or amend documents, what percentages of or do we need to of the homeowners association or the members of the association to amend documents to make changes. What can we do? What can't we do? What are our procedures for collecting assessments, for enforcing assessments, for enforcing the bylaws and the restrictive covenants? So we're kind of we have deed restrictions which tell us what we can and can't do, but how do we enforce them? And how do we, who has the authority to enforce them? So when we don't have things spelled out in our bylaws or amendments, we have to go back to the Florida statutes. This association, because it's a homeowners association and the way it's set up, is governed by Chapter 720 of the Florida statute regarding homeowners associations. That gives us the procedures, tells us what to do when we don't have our own set of governing documents. So we're kind of coming into a situation where we have an association that was kind of haphazardly enforcing restrictive covenants for, I guess, the past 20, when were we first in the early 90s? That's 20-some odd years.
Incorporated in 85.
Okay. So way back there. But that has been kind of, I guess, sort of improperly, from what I hear and from what I can glean, improperly enforcing restrictions, sort of making, asserting authority that they didn't have the ability to do, telling people that they're not part of the association when they have no right to tell them that, simply because they have said them. Any lot owner, anyone that is an owner of the property within this homeowners association is a member by virtue of that ownership, and that entitles you.
I was told that unless you live or rent or whatever, if you own a house, you are a member of the homeowners association. But if you have a piece of property, you are not. You own the property.
You own the property, and if your documents restrict you from doing that, if not, by virtue of being a lot owner, it may give you a different type of membership. Sometimes governing documents, if it's undeveloped property, will give you a certain type of, like a Class A right to vote, and that entitles you to certain things. And if it's improved property, meaning it has a home or a structure on it, then that would, you would be maybe considered Class B, which gives you another set of rights. But that would be spelled out in the governing document. If it's not in the governing document, as a lot owner, you are entitled to vote just as much as any other right. And if it's not spelled out, we'd have to, and I don't know specifically in your documents if it's delineated. I don't believe it does, because it's so brief. The initial document, I believe, is 2 pages. But if not, you have a right to vote as a member of the homeowners association. As a homeowners, yeah.
I'm sorry for interrupting.
No, anytime. Anytime you have a question.
Preliminarily speaking, what is the nature of this meeting? Is this a homeowners association meeting?
Right. This is a homeowners association meeting that was called by the existing board to address these. And our role in being here was to address certain issues regarding the state of the HOA and to help people get on the same page. I know that.
To that point, if this is a formal HOA meeting, we don't have a quorum to proceed.
We're not having.
We're not voting on anything.
Okay, so it's a meeting.
It's just an informational meeting for homeowners association. It's a meeting for HOA, for the homeowners association members who'd like to attend and to provide information and education. for the members.
Thank you.
And hopefully resolve a lot of the, because we're a community, or you guys are a community, you live together, and as long as you own property there, you're going to have to deal with each other. So we want everybody to just to get along and to have a productive environment where people want to live and raise families and retire and do a neighborhood that they want to live in. So,
Thank you.
so that's it. Thank you for asking that.
This meeting was not advertised as an HOA meeting. It was an information and educational meeting for property owners and
Okay.
owners.
And that's why I'm here.
So then it's not a homeowners association
Good
meeting?
lady.
Property owners.
Well,
I'm just trying to
and
clarify.
I don't want to mince terms, but it is
I do.
the property. Well, not mince terms, but from what she's saying, it's a homeowners meeting. We're not voting on any. It's not a special meeting where we're voting on something and it's limited for those purposes. It's for educational reasons and to inform homeowners of their rights under the governing documents. Because
So the assumption here that everyone in this room is a property owner in the neighborhood.
the assumption, well, it's not because she is not.
She meaning?
Sherry is not a property owner. And so she's also, because of that, she's not entitled to be on the board.
So if this is a homeowners association meeting, I want to clarify because we have very real issues here that we're not creating, we're just responding to. And so to that point, we're getting letters from lawyers, that sort of thing. So when people start attacking us, I want to clarify what exactly is going on here in terms of the nature of this meeting because it informs our decisions going forward. So to that point, to clarify, sir, this is a homeowners association meeting. Is that correct or is that not correct?
It is a meeting for educational purposes for the people who own property in the association.
So if people who don't own property are here, they should depart, or is it?
I think because she is a representative for homeowner, mainly your son who owns the property, you live in the property. She's here on his behalf.
And
which is fine, but anyone can do that. So if you're a tenant or a representative for an individual lot owner, that would be fine for you to be here. They would not have any.
Pursuant to what? Is there a statutory clause
You
that
can have
says?
there is like for example proxies or representatives that they would have the ability to be there on their behalf. If not, is there anyone that objects to a non-property owner being here?
Well, you're talking proxy, and you're saying this is not a homeowner association meeting, and that means we don't have a quorum, but you're talking proxy.
We're talking about proxies and forms. We're not voting on anything.
Right.
It's strictly information only. It's strictly,
So, like those that don't own the property and are represented like this way to give someone else, if this was a meeting for the association, she
do not vote. No, absolutely not. Absolutely not.
But in terms of attending, that's a non-issue.
It's just because we're not.
And there's a statutory provision that allows a
She is
homeowner to have a
appoint a
representative.
representative to attend a meeting on their behalf.
Thank you.
Yes, ma'am.
I have like a two-part question.
Okay.
One, who's paying for this hall? Two, who's paying for you to give us this information?
We were retained by the current board.
And the current board is?
The current board is the three women now, which are Connor, thank you, Cherie, and Phyllis and Young. Now, technically, Cherie can't be on the board by virtue of her. She's not an owner of the property, so she couldn't be on the board. But the other two.
So then my question would be is, should this not have been a community that decided that we could spend our funds on something like this?
You can't, the community couldn't know because you have a board that was, with the exception of Cherie.
But wasn't the right thing to do was for us to have a meeting to see if we're going to pay for stuff like this?
That the board.
And our funds are being spent wisely.
Right. Let me back up a second. The board has the authority to retain counsel. They have the ability to do that. Number two, if there's a concern among any homeowner regarding whether funds are being spent wisely or not, under the statute statute, it provides that at least if 10% of the membership, which would be the homeowners, if we have 10% of those voting members, they can call a special meeting to determine, and it would be noticed the same way a special meeting, giving 14 days notice to all the membership of the special meeting with the date specified, would be, you have those, if 10% of you, of all the lot owners, agree, want to have a special meeting for whatever purpose, noticing the meeting, giving the purpose of that meeting, they have the authority to send that notice out to all the owners and then conduct that special meeting and present those things for voting and with the same proxies, etc. They have the same authority to do that. Now, as far as giving notice of that special, does the board, going back to your question, does the board have the authority to retain counsel to do that? Yes, they have the authority to do that.
Without voting?
Yes, they do.
Without voting, yeah, no, they have the authority to do that.
And how do they do that, excuse me, sir? How does the board get together to retain a council?
How do they get together?
Yeah.
They can have a special meeting.
And when was the special meeting handled by the board?
I can't tell you that because I don't know the answer.
Are there any minutes to that meeting that the board had a meeting to retain you, sir?
They may.
I do not think so, because the last we heard, there were no board meetings since they were elected in November.
But they have the authority to retain counsel to do that.
In which way, sir?
But they can just retain it. They don't have to have a special meeting to do that. They could meet to say, we need to do that. Essentially, they would retain.
And that's in the statute,
So,
sir?
that's under the authority of a board, yes.
Okay.
A follow-up, if I may.
Okay. But before we go...
kind of one important point,
Wait, well, hold on just a
Okay.
second. The purpose of this is to give you some information. If you want the information, that's fine.
Well, we're trying to ascertain, the propriety of this meeting and the expenditure in you being here. Because, as you mentioned, the board consists of 3 people, one of whom is not properly a member of the board.
We got the dress.
Right, and that's the president.
Right.
And so then there are 2 members left. I'm wondering if for the board, in order to make fiscal decisions, such as expenditure of funds for lawyers, do you have to have a full board? Can it be a partial board? Can it be one person all by themselves on the board who makes fiscal decisions that bind the rest of the homeowners? So if we have 2 board members and we have slots for 4, I'm trying to understand, do the 2 proper board members, considering that there's 4 slots, do they have authority to act without filling the other slots and making these types of decisions?
It is what it is until you have that. Now, we have this board, they've done that. At this point, and I'm going to bring this up now, all of your current board members are resigning. They've given me those resignations. They are all resigning. Sherry because she can't. The other 2 because this is overwhelming for them. And it's causing them great grief and anxiety, which happens. So what do we do now? When there's not a board, we have a situation where we have to elect a new one. Now, I know that there was a recall, and the process for doing that recall was not done properly, and I know that there's a recall hearing for next week. Proxies have been sent out, which are also not proper. I brought the correct forms for you to do that if you want to recall the board, just so it's done correctly. I mean, again, this is a group of homeowners. We want this to be a successful community, whether you decide to update your documents or not, or whether you decide to do away with the HOA altogether.
And the purpose, you were retained first part of April for the purpose of writing the bylaws that had never been written, and updating our old, outdated deed restrictions.
Right, and none of those, and let me just be very clear, is that the board doesn't have the authority to enact bylaws just ad hoc, or update amendments. They can't do it. It requires, at least under the statute, 2/3 of the voting membership to do that. So if we're going to have amendments, we recommended this is why you need them. You need bylaws, so there's some clarity about how you govern yourselves, particularly for the reasons like this. And then in laying out, so a homeowner coming in there, a property owner, a purchaser of property coming in, can clearly understand what my rights are and what my obligations are by being in this community. So that to alleviate some of the friction that we have going on and the issues with enforcement. So that's the goal there.
The friction was caused from the lack of meetings, the lack of communication with the meeting.
Right, and
That's
also,
where the question started.
well, also too, but it's not clear. But see, also too, a lot of people being given misinformation and not knowing what their rights are because it wasn't a place where they could go to and clearly see.
Exactly.
See, again, for having the bylaws, the correct information in the bylaws, clear bylaws, deed restrictive covenants that provide for it. Do we have assessments, or are they just voluntary? Your assessments are voluntary. You don't have it. There's nothing. There's no enforcement provisions in your governing documents requiring you to pay assessments at all. And I have a feeling that a lot of you didn't know that.
We didn't need it.
We've had, over the years, I have been the treasurer for about 9 years. And when Rex Hawley was the president, I clearly remember him saying, we are keeping the homeowners' dues at $50 a year.
That's fine, but you can't. It's voluntary. You can't force somebody to pay something that they are not obligated to. If they want to, they can. I can pay your assessments. You can accept it, but you couldn't force me to.
You make an assessment. Assessments and dues are two different things.
Like assessments are right, exactly.
Right.
Assessments or dues. There's
Okay,
no
so
duty to
you
collect
want
an annual dues or monthly. Sometimes we call assessments like an annual maintenance assessment for.
Actually, the
So there's currently no, I'm sorry.
Go ahead.
So there's currently no authority to levy special assessments, is that correct?
There's currently no just dues, annual dues.
Right,
There's
but my
nothing.
question is, does the board currently have authority to levy special assessments?
No, there's not.
Thank you.
But the deed restrictions and bylaws and articles of corporations do mention dues. So
There's no
if-
bylaws. You don't have bylaws.
Why do you say that?
Why do you say that?
Because it's not recorded.
It's in this wonderful big book that we have here.
But they're not recorded.
I think they
So
are.
the clerk,
I think they are.
no, they're not recorded in public record.
You might be right. Let me check.
But while Pat is checking, if we have that in our
They're not recorded.
bylaws or articles or deed restrictions, etc., will they not then be an agreement of the community?
They would,
to
at
pay
this
them?
point, and I would want to look at that because if they were done a long time ago, they weren't recorded. Then at this point we would probably, and this is an issue that hasn't come up before for me, would be that we would still want to have them approved by at least 2/3 of the
Sure.
in order because it's 25 or 30 years, like 29 years later. Were they done in 1984 or 85?
Quite some time ago. They're not dated, in fact.
Yeah.
They're undated. But so...
Were they probably? And you
I
can
don't
call me
even-
Scott.
Scott?
You have to call me sir
right.
because it makes me feel really.
old. Sure, Scott. Yeah, I don't even see that there's any kind of execution on the back of them. It's just...
You know, if they weren't executed, and sometimes too, bylaws that are in a corporate kit, they may have come with a corporate kit when they ordered
Actually,
it.
no. They actually were
The bylaw, were they
written
specific?
by an attorney. However, there's a good chance that the community agreed on them, but they were not
Yeah,
recorded.
okay.
So
Yeah, they're not
Because sometimes I know, like when we order corporate kits, the printing company will just send a
I
form
know.
bylaw.
Yeah,
and,
but yeah, no,
so,
these are not standard. But that's all right. I mean, that's an easy
So,
fix. We'll have the
But
community vote
I want
for
to talk
that.
to you guys because I know that you have this recall meeting coming up this week and doing it by proxy, and when we're doing recalls versus the procedure's a little bit different. So since we don't have a board here, what we may want to do instead is have a notice of meeting, a special meeting, 14 days notice, for the purpose of electing a board and having an election and following the procedure for that, as opposed to going through the entire the recall procedure, which hasn't, the proper form has not been sent. So, and I'll give that to you so you can see it depending on what you want to do. But technically, as of today, there is no board. So if the proper, I think there was a recall back in, was it October?
There was a general meeting in August.
But was
There was a recall
April
a couple
12th.
months ago.
Yeah,
April
okay.
12th.
Okay, and that wasn't done properly.
Yeah, we know that.
So let's instead of going through the recall procedure, let's have a general election.
We are.
So and do it. Has it been properly noticed?
Yeah, absolutely.
Was
And that's
not,
what
not
we're
the
doing now.
not the recall. I'm talking about the general election.
Well, let's not worry about that, because if the current board is resigning, that's a moot point as far as we're concerned. Because then the...
Well, it's not a moot point. No, absolutely not.
There's
Because
not
you're
as
required
much
to have a board if you have a homeowners association.
But the
You're required-
imperative is not as pressing upon us, and we can rectify that amongst ourselves. So that's okay. I appreciate that, but we don't.
Well, no, it's not. No, I don't think you understand.
I perhaps don't.
So because don't assume that it's not important, because it is. You are an association that is currently in this situation. You're required to have a board if you don't have one. Mm-hmm. This is so that's part of.
We're not disagreeing.
Don't worry, we're fine. Okay. We agree.
We will elect a new board.
Okay. And again, I don't want you to see me as adversary, because this is about the association. If you want to, I know that you've sent out the notices for the recall. Have you separately sent out notices for an election?
Part of, let's move on.
Well, no, I don't want to move on. I want to focus on this, because if you're going to do it, you need to do it correctly.
We're not here to answer questions. We're here to ask questions, and we'll certainly listen to you make your presentation.
I'm not just talking to you two ladies. I'm talking to the group as a whole. Okay.
Fair enough.
So.
Well, the notice said elect new members. It said just vote to disband, elect new members, and then vote to the items of
I like it.
Right. That's what I'm saying. So then you're asking them if they.
Well, because I know that they've sent out letters, and you've organized a lot
And
of.
I'm sure you got a copy of it. In that letter, it's one of the options that we will discuss and vote on is elect a new board. Yes.
So just make sure that you've done. If you're getting a counsel from
We're not.
Okay. Is to make sure you've done it properly, so you're not going to have.
We appreciate that.
Thank you.
Okay. So I don't understand why there's.
I don't either. We're just saying, let's move on.
No, but I don't understand why. If I'm here to, why there's reluctance to.
You're here to provide information. We're listening.
I know, but it just seems a little animosity, so I'm not sure.
Oh, there's some animosity. We've been through quite a bit. No, you're
no,
fine,
you're
sir.
in the
Scott.
You're fine in the bystander.
So I know, but I just want to. I want to. You all live together.
Yeah, we do.
Yeah, we do.
Member is a legal organization of an HOA. They must notify by mail, by email, or personally. How do they?
By mail.
By mail. In other words, we have to get notification in time to get that notice.
It's 14 days notice. 14 days notice. Let's see. Just a couple other things too regarding your HOA documents. If you're going to amend them or revoke them at all or cancel them, it has to be by two. You have to have 2/3 of your membership. Also, too, your restrictive covenants will be 30 years old soon, and under the statute, they will automatically expire. And so you all have to decide whether or not you want to renew and extend them, or whether you want to just let them go by the wayside. If you're within the 30-year period and you want to extend them, then you would. There's a procedure for doing that and extending them. If you do not want to extend them and they expire and then you want to reinstate them, you would have to have 2/3 of the membership agree to reinstate them. So that's something to consider in the future. I think that. Was there any other issue that we wanted to talk about? Oh, I would just, for whomever becomes the new board, if you're going to enforce things, don't do things face-to-face and knock on people's doors and tell them, you need to do this or I'm going to, kick you out of the HOA. I'm not, the bullying tactics don't work. There's a procedure to do that. Send letters.
I understand the not bullying, but a courtesy nod.
It is.
Never happened before.
Way better. And I don't know what some of the first letters were like, but, by the way, do you know, that's fine, but always, follow it out with a letter if you're going to. Don't let the courtesy not be the thing that's saying, okay, you didn't do this, so now I'm going to put a lien on your property or enforce, none of that,
Give the person the opportunity to correct whatever
It gives
before
them,
you call it
right.
county.
No, that's not good being a good neighbor. That is not a good neighbor. And let me just say, I got you. It's a good point. And that is just being a good neighbor, giving somebody the opportunity to respond, follow it up in writing. The purpose of the HOA is to enforce the regulations of the HOA. County rules, anybody can do that. I could drive through your community and say, I don't like whatever that is, and it violates the county rule, and I could enforce it, you know. But, you know, I live in Lakeland in a historic district. And specifically not an HOA, because HOAs have lots of problems sometimes. But we have the city people coming through all the time, and this is not like some great architecturally relevant place. It's a bunch of old houses that are, you know, very often derelict buildings, and, you know, it's just, but they will come and arbitrarily enforce things like furniture on your front porch, or the wrong kind of windows and things like that, and then they'll let the guy next door get by with, you know, growing weed in his backyard, you know, that kind of stuff. It's just arbitrary. So I get it, and it's not the best way to do it. The best way to do it is, okay, you know, maybe mentioning it, if nothing happens, okay, let's send a nice letter. If that doesn't happen, send up a follow-up letter, this is what's going to happen, here's our authority to do that under our documents. And then if that doesn't happen, okay, you are just being a jerk, and, you know, we're abiding by the laws, or the guidelines that we set out. You need to do it too, and if you don't, this is the repercussions of doing it. This is our authority to enforce it.
We historically really haven't had problems with this sort of thing, and it's been a recent development, and I think prospectively going forward, we're probably not going to have these problems again. So it's
hopefully,
kind of a point.
These are things to be aware of.
And we appreciate the recommendation. It would have been nice if you would have given the current board the same recommendations when they started, because that's where the issue started. But that's all right. I mean, we all learn from mistakes and we move forward. So thanks.
But I'm not sure what the first meeting was like, because I wasn't there.
Right.
But, you know, it sounds like you have a great place to live.
We do.
Nice big lots at 89, you know.
We do.
And, you know,
we promise to be
probably a great Christmas party. Just behave and get along and maybe have a great Christmas party.
You're singing to the choir.
No, we're aiming for a July 4th party.
July 4th party.
So I do have two questions here. So you advised us that the board is resigning.
The board is resigning.
Effective when?
sorry.
Yeah, let me ask my question. Thank you. The question was effective when, and can they change their mind tomorrow, next week, whenever?
No, I mean the resignations, and really, and that's gonna, I'm not, you know, they're effective when they're giving them. So right now, they, you know,
they've given it to you in writing, right? If we by any chance ask for copies of that, thank you.
Copy it here, there probably is.
Well, you're more than welcome to, I give you my email, you can email me,
We can
or...
scan them, yeah. In fact,
that'd be
if you
lovely.
will, do we have your email on?
I will share that with you later on.
If you will write it right on the front of this, because this is what it's going back into. And anyone else who would like a copy.
Yeah, I'll go ahead and share it with the community.
Okay.
That would be good.
Okay.
And so now that the board has resigned, if we have a meeting next Saturday within statutory time limits, is this an acceptable time?
That's my concern. As long as it has been properly noticed for elections.
Correct.
And proper, you know.
And it has been.
Right. In that time.
Okay.
And you could do the election by proxy. Now, if you're doing a recall, you didn't send the right form for that. So, but we don't have
That's a moot point.
That's right, exactly.
Beautiful.
Yes.
I'm going to take you home with me.
No, she's coming home with me. Not to worry.
No,
I'm an Irishman. What can I say?
but, yes, ma'am, sorry.
So just explain that, what it has to be ready for all of your questions.
For the notice of the special meeting.
Oh, why don't you do that? Actually,
Okay, is there, do you know?
I can take a photo of the
Yeah,
document.
that's fine, sure.
Thank you. Good point.
There's just the three of us. She did receive the notice.
I'm
for the
sorry.
special meeting.
I don't know your name. I'm sorry, I don't know your name, honey.
Mrs. Brown, we're the ones building.
Mrs. Brown, I am almost positive that I received a certified return receipt note from you that you received it. If not, I'll be more than happy to touch base with you.
Oh, I'm going to attend because we've been going on
Excellent.
property every day to see how our house is coming.
Lovely. We would love to all meet you. Yes,
So
you're welcome.
I'm reading signs.
Please.
As far as anything legal, I got a legal thing that this was.
We just shared a notice with everyone, but after the meeting, I can go ahead and exchange information with you and share everything with you, ma'am. Okay? Good. Thank you. you.
Because I'm not computer savvy.
No, we mailed it. We did not send it via email. We mailed it.
Well, let's follow up with this a little bit later when this gentleman's not on the
Just
clock.
like
Is that
afterwards,
okay?
and then, yeah.
All right.
I stopped my clock.
Thanks,
It's
Dad.
not on the
You did
clock.
not stop
I
it.
really did. I'm not, no, I'm not. And no, really, I'm off the clock. You will not be billed for this part of it. I'm billing for half an hour for the meeting, and that's all I'm billing for. But because I want you to, get it right, I don't want you to feel like, and attorneys, and I don't get invited places.
We should have brought cupcakes.
You should have. That is not.
No, I was saying it in a nice way.
Yes, I felt that. But does anyone else have any other questions?
Anything on our list?
Well, I'm going to wait and see if anybody else does before I tender more.
When we bought the land, I was told that the association was inactive, there wasn't nobody's doing anything. And the reason that we bought that land is because we didn't want an HOA.
Right.
And we're elderly, we're not going to be destroying things. We just wanted the peace and quiet of a nice neighborhood.
You have nothing to worry about. That's how it's always been historically until recently. So don't worry. It's fine. You'll be okay. We're not going to run around like, issuing citations to you. Okay? You're good.
Yes, ma'am.
If the current board has resigned, what happens with the checkbook?
The checkbook, well, let's see, what does happen? What would you guys like to do with the checkbook?
We'd like to have it up.
We'd like to get possession.
Yes, of all the documents as soon as possible. Yes, please.
Let's arrange for, of course,
Transition.
There's going to be a receiver and make arrangements to get everything handed over.
You know what? I'm an attorney. I'd be willing to take possession, hold the documents in escrow until another board is elected, if that's what they want to do. I can take possession, inventory them, hold them in escrow, and then when they get that way we don't have to continue to run up legal fees. I'll do it, and then whenever the new board is elected, I will then release them from escrow. Is that reasonable?
I think it is. I would like to have some type of escrow agreement before that handoff is done.
Yep.
And just
Let me go
put it
back
over.
to
Sure.
And, I'm sorry, what was your name again?
Pat? Carol?
Carol, okay. You have, could you write down your contact for us?
Sure. I'll give you a call.
And or make sure I can get it. Sure. And then we can put an escrow transfer agreement
Cards
together.
are in my cost.
So I have a follow-up if everybody else is done. I don't want to be, monopolizing
Go
the
ahead,
meeting.
hog the meeting. Go ahead.
So a couple quick, succinct questions.
Yes.
Have you guys already compiled some proposed bylaws and restrictions or anything? Have you crafted any documents?
I will ask Dan. I don't believe that they have at this point because we didn't want, until we had the authority to do so, we didn't want to bill you for that.
Perfect. That was what I was
not very
asking.
lawyerly of us. We should have really just gone in there.
I'm actually happy that you didn't.
I know, that's why.
No, that was exactly
No, we
my
haven't.
question.
To my knowledge, we haven't.
Now, records requests, I guess that's kind of a moot point now anyway, because we had made some records requests.
Well,
but
I
this isn't
saw
gonna
the
be-
May 2nd letter about...
Yeah, that I would make my office available. But that's kind of a moot point at this point. If we're going
We're going to be handing them off.
Assuming that that's going to happen in an orderly fashion.
It will.
Arguendo, if it does not happen in an orderly fashion, then how can we get copies of the records? Because at this
We
point...
have the records on the premises,
Right.
right here today.
Right, but we
Everything.
okay. Yeah, we don't have a copy machine with us here, but I do have a Mac Daddy copy machine in my office, and so if we have no problem with
to have copies? I'm
no.
gonna turn over
I'm saying
everything.
Entitled to.
I'm saying thank you. I'm saying because you're representing that the board is resigning, and that those records are going to be turned over or potentially held in escrow pursuant to an escrow agreement. That failing, because I've had discussions when somebody said they're going to do X and they didn't do X, they did Y. So arguendo, that failing, I still need to, if that fails, then...
Under the statute, you have provisions.
Yeah. I mean, can we...
Provisions like you get $50 a day.
Yeah.
Provisions, minimum. So there would be that. This just came to me while we're talking. At your... meeting to elect officers next week.
Right.
I would at that time recommend that a vote be taken to accept the resignations of these members. they've given them, they can be effective immediately, but formally affect them. And at that same meeting, everything could be handed off at that same time when the new board's elected.
Now, if the meeting hasn't been noticed to accept a resignation specifically, I don't want to get bogged down with get an attack on the minutia, such as, was it noticed that we were going to take a vote
I think it
to accept the resignation of the board?
Well, the thing about it here is that they can resign whenever they want to. You know what I'm saying? We don't have to. It's just a formal, the formality of the board.
So my question is, can we execute that formality not having noticed it?
I think
yes
so.
I mean,
yeah. I mean, just accept, if someone gives you, it doesn't really matter because they can still resign.
Right.
They resign. They're not going to act, and you have properly noticed the election.
Perfect. Thank you.
But I don't think. Yeah, I don't. So I don't think that we would have an issue. But I would, at the same time, just so it's neat and clean in your minutes.
And in the minutes,
Mm-hmm.
yes.
That's great. Thank you.
Appreciate it.
And then we could also, at that time, formally do the ceremonial handing over of the everything.
So I have another follow-up, if I may, if nobody else does, because again, I want to defer to anybody else who might have a question. So how much has the HOA paid in attorney's fees to date?
I don't know what they are. Our retainer was $3,000.
And is that a flat fee retainer, or is it hourly billable?
It's an hourly. It's billed hourly.
So do you know how much of that $3,000?
I do not know.
Do me a favor. I'm bringing a record here on the tape recorder, so I'd like to get my sentence out.
I'm sorry.
That's quite all right. So at this point, you don't have with you specifically how much has been expended from HOA fees. Is that correct?
I don't.
Because that's going to be a question posed to us next week, and that's why I'm posing it. Not that I am, you know what I mean, giving you a hard time.
To follow up on Pat, sorry to interrupt, but since I will be giving you my email address, will you be kind enough before the meeting next Saturday to send me an email and give me maybe some details?
I can give you a detail of what that is.
Exactly. That would be fine. Thank you.
No, absolutely. That is not a problem. Yes, ma'am.
Have to take into consideration when we retained Pelican and Associates, that was strictly to write the bylaws and update restrictions, whatever we need to do to be updated for our HOA into the future. That did not include all of the other things that have come up in the meantime, telephone calls and emails that have taken Dan's time. But that was not a part of that. So what's expended so far has been on this other stuff that's been going around and not necessarily the bylaws and the deed restriction of the new bylaws of writing the bylaws and the deed restrictions.
That's a correct observation. Yeah.
So if funds have been expended for services in this whole debacle by a board, one of whom is not properly a member of the board, they have a irrespective of what, would you agree, that irrespective of whether or not someone is properly a member of the board, if they take possession of other people's funds, they are a fiduciary. Would that be correct?
I'm not going to answer that because it has broader implications, so I'm not going to answer that.
All right. Well, I will submit that a person who presents themselves in an authority figure, such as a president of a board, when they have no authority to act in that capacity, and they take possession of funds and sign checks and expend those funds, I would submit that person's a fiduciary. So assuming that and I believe HOA boards are fiduciaries, you can confirm that, correct? All right. So if a person who is improperly sitting on the board takes possession, I do believe that irrespective of whether or not they're properly in that role, they are a fiduciary. So if a person is in that role as a fiduciary and they don't have authority under the law to expend funds because they're not properly a member of the board, would they be personally responsible for the funds they expended?
I'm not answering that.
Okay, thank you. I understand why. I do understand why.
I would put a caveat to that while that's maybe one member, we do have a remaining board that at that time that were properly board members.
But that goes back to my prior question, which is if you have only 2 board members and you have 4 seats, and the board hasn't fulfilled their duties, which is that they have to appoint a missing board member within 60 days. So if they fail in that duty, and then they're making funding decisions, it seems to me that there's
That's a,
significant
that is
violation
a
of
good
fiduciary.
question, and you may, I see where you're going.
Yes.
Clearly, that would be, that's
Something for the courts to decide.
That is exactly an equitable.
Thank you.
You know, an equitable question because we don't have a clear.
Right.
Hopefully, you know.
Hope left the back door.
What did you say?
Sorry. No, nothing. I'm sorry.
Was she being
She was making
And I will ask her a copy of that tape and ask her to rewind it.
Oh, you can have a copy.
I know.
Thank you.
Yeah, this is a public meeting, so
Yeah,
you can have a copy.
she won't change anything to me. Does anyone else have any other
I
questions?
was just curious, was there a specific date when the board became inactive and active again? Is that inactive? I always thought it was inactive.
It's always been there. Other the documents that you have available, you have a valid homeowners association that's properly incorporated. You have restrictive covenants that provide for a homeowners association. They may have been active just because no one was really enforcing them. That doesn't mean that it could become active.
But in this newsletter, the message from the board, a lot of that in the community, it's like general election of August 3rd, 2013. So that means that prior to that, they were considered active. There was never an inactive.
I don't know how the board regarded itself at that time, or the HOA regarded itself. It seems like there's been a lot. Just some of the things I've seen a couple of things I think from the early '90s.
Wait, just a quick comment. Yes, the board has been active since the neighborhood was established. Some years it was more active than others. So in the quiet years, in the sleeping years, most of the neighbors did not understand that it was an active board, still paid dues, still paid bills, still collected dues, etc. But when it was inactive, everybody thought it didn't exist, unfortunately. But we aim to change that.
Well, I hope it works out. It works out because it seems like a nice group of people.
Thank you.
Thank you. If you have questions, contact me or contact Dan Pilka. I just want to say something without it being on.
Of course. Off the record. They say it in the movie. They're very hard-working people, and believe it or not, $50 a year for some folks that may be on Social Security is a big deal.
Well, they're a huge deal. I mean, if you guys have got to decide, do we want these or do we not want them? You know, is this a pain in the neck or do we want it?
Is there any kind of state requirement? Is there any kind of state requirement that requires us by law to bring all these documents up to date? I mean, and if not, we'll be penalized because that was what was represented to me. Is that
no, not that you'd be
incorrect?
penalized. No, because if you don't have them, we're gonna have going back to the law and what the law says and to try
Right,
to
but
make it
if
work.
we have good documents that the community agrees to, can we
fine.
still use them and just reinstate them?
All right. I mean, if you want to reinstate them,
Sure.
Next 3 years they're gone unless you guys want to revive them. And also too, any association member, any member can reinstate them. All right, thank you. Can decide if they get enough people behind them to pursue it.
Right, okay.
I do want to say I missed something. Because the other notice that put out, it says that they're going to do 3 things. The last thing is to disband the board meeting. So we're not required to have a board, right? Is that legally we're not required?
You could have to as long as you have there should be a board if you're going to have an homeowners association. If you're going to disband the homeowners association and you're going to disband, no longer have your homeowners association documents, then your restrictive covenants, then you'd have to have 2/3 of majority to say we're not going to do
Actually,
that.
the notice gave options. So in the meeting next Saturday, we will discuss these options. There were 3 things exactly, and we would that was the notice by statute to discuss these items. So statute 617, by the way, allows us to disband the board if we.
But you're covered by 720.
Right. But
617 is like for
right, but as a non-profit organization, statute 617 does apply when we get to that option. But we may not even need to do that. It was just an option.
Frankly, that was placed on the notice because we were being threatened with being drugged into arbitration and mediation, and we were concerned, if I may, about having legal fees running up. So to try to avoid a lot of legal fees run up on arbitration and mediation where perhaps special assessments would be levied, we said we can't we were in a big pickle. So what we did was just put a notice that that if we can't get it rectified, then we should disband, because otherwise we're going to be running up a bunch of legal fees. But that is not our desire, to disband the HOA. That's not our desire to do, because we've always had a very positive HOA that's been non-intrusive, but it's always been very friendly. So we'd like to get back there.
They didn't have to abide by what Tallahassee told us in July of last year.
Sorry?
Sweeping changes were made to the HOA rule in July of 13th of last year.
Yeah. But do they affect us?
Well, yes, they affect every HOA in the whole.
But that goes to my question: if we
You
don't
don't have to update your HOA documents, but if you don't have to make changes to them. If you don't, the statute will supersede what's in them.
Right.
Yeah, fine.
So we didn't really, if we didn't want to, we didn't have to do anything. The statute was...
Again,
Right.
it's for the ease of operation for your...
I understood that.
And that is what we recommend, because to avoid a lot of the pitfalls and pitfalls of having this association.
Pardon me, not being facetious or anything, but if, as a community, we did not want to take your recommendations, we could stay with or with the statute.
No, exactly.
Understood.
And if we didn't want to expend money on legal fees to update all of our bylaws, then by operation of law, we would have been